now we will be turning to the another kind of a doctrine or the rule which is known as the jurisdictional rule of reason, which has been laid down by Justice Adam in Mannington Mills Incorporation versus Conglium Corporation 1979, and applied jurisdictional rule of reason in the context of antitrust litigation in overseas conduct. The cumulatively impact of these rulings broadly expanded the notion of extraterritoriality, the merger of the conduct and effect test with jurisdictional rule of reason in the competition law sets new twist to the extraterritorial application of competition law in United States. It is not out of place here to mention the Morrison versus National Australian Bank Limited case of 2010, wherein the Supreme Court endeavored to set the expansion of extraterritoriality by laying down a statutory intent for extraterritoriality. And dear learner and viewer, it is at this juncture you have to underline that the expansion of extraterritoriality was made subservient to the statutory intent of the extraterritoriality and held that a presumption was not clear rule and was rebuttable by a clear indication of extraterritoriality. Then we will be discussing that what is exactly meant and connoted by the presumption of a statutory intent or the presumption of a statutory intent as has been laid down by Justice Adam in Mannington Mills Incorporation case and Morrison versus National Australian Bank case. The exact connotation of the presumption of the statutory intent entails the very fact which is being laid down in RJR Nabisco Incorporation versus European Community case of 2016, where the court has an occasion to extensively examine the presumption of statutory intent of Racketeer Influenced and Corrupt Organization Act of 1970 and apply to the acts committed outside the United States if the defendant is a United States person. Thus, what we infer out of this that the Morrison instructions that the statutory intent and RJR Nabisco's cases endorsement jointly provided an additional ground of application of extraterritorial jurisdiction in matters of antitrust law and the competition law, and the court in an unmistakable term stated that such intent can also be found in examining the structure of the statute, and an express statement of extraterritoriality is not an essential for determining what you can say the statutory intent of the legislature. Then we will be discussing again the conduct and effect test, which has been first and foremost laid down in Alcoa case in 1945. The Supreme Court's opinion in Morrison paved the way for the Congress to the enactment of Dodd Frank Wall Street Reform and Consumer Protection Act, which is popularly known as the Dodd Frank Act 2010. And Section 929P, subclause B, specifically contains an extraterritorial jurisdiction in matters of securities law. Nonetheless, Section 929P, subclause B, applied primarily Section 929P, subclause B, applied conduct and effect standard to apply if the conduct within the United States is significant. or external US conduct has a foreseeable and substantial effect within our country. Legally speaking, Dodd Frank has overruled Morrison Case and further strengthened in Escovillo versus Securities and Exchange Commission 2019 the principle of extraterritoriality under Section 929P subclause B of Dodd Frank Act under the garb of conduct and effect doctrine. Now, dear viewers and learners, we will be devoting some time to discuss the Foreign Trade Antitrust Improvement Act in 1982, which the exercise of extraterritorial jurisdiction in the context of antitrust law was 45 and established in relation to foreign conduct that was meant to produce substantial effect in the United States. The American antitrust policies assume in an act of legal imperialism through a kind of a legislative fiat. To buttress this privilege of export cartel, the US Congress passed Foreign Trade Antitrust Improvement Act in 1982 and created antitrust liability having import commerce and direct, substantial, and reasonable foreseeable effect on domestic commerce under Sherman Act 1890. The Clayton Act 1914 also provided antitrust violation by price discrimination, exclusive dealing and time contract, acquisition of competing companies, and interlocking directorates, the so-called the triple damage theory underpinned in the Sherman Act and the Clayton Act 1914 and Foreign Trade Antitrust Act 1982 regulated antitrust damages in extraterritorial context. The salient features of the Foreign Trade Antitrust Improvement Act was 1982 was to govern the application of the Sherman Act 1890 to antitrust violation that has occurred in abroad. While a statute received little attention in early years, public and the private plaintiffs have recently begun to collect large fines and penalties under its jurisdiction. As a member of parties subject to these judgments have continued to grow, the increasing focus of the FTAIA, shortly known as, has caused an uneven development of a statute, while certain aspects of FTAIA were defined and redefined by the catena of the cases and judicial interpretation. The language in the statute, though remain undeveloped, but the comment proposes a new interpretation of the direct, substantial, and reasonable and foreseeable effect requirement of the FTAI legislation of 1982. Thus, we see that the new interpretation provided the court with the means to interpret a section of FTAI Act by balancing provisions of judicial innovations and deciphering the statute with the intent of the Congress. FTAI discusses its provision and examines the critiques of the judicial treatment and conclude that wrong policies of statutory interpretations or the basic canons of the statutory interpretation should be applied in matters of policy and judicial direction and legislative correction, be that the Sherman Act, be that the Clayton Act, or be that the Foreign Trade Antitrust Improvement Act of 1982. Having understood the gist of these three key enactment on antitrust law and the competition law and its potentialities in the extraterritorial application of the competition law. Now we will be referring to the restatement third of the Foreign Relation Law of the United States of 1988, which in fact indoctrinated and incorporated the effect test and the jurisdictional rule of reason in antitrust cases involving foreign parties. Thus, what we find and notice that the foreign government have reacted negatively towards US courts' application of antitrust laws extraterritorial jurisdiction. The restatement third 1988 is a kind of a Philip exercise which provides a guideline for determining jurisdiction over competitive activities and addresses the right to compete in the deceptive marketing, the concept of intangible property, and the correlative right. The jurisdictional rule of reason principle, which has been underpinned in the Act, happens to be a kind of a tool of international committee to determine the court jurisdiction. Thus, the internal treaties and active participation by the US executive and foreign government can help to address some of the political issues which are related to the application of antitrust law in territorial and extraterritorial jurisdictions. In this respect, we have to refer to Section 402, 403, and 4015 of the Restatement Third of 1988, a combined reading of Section 402, 403, and 415 of the Restatement Third of the Foreign Relation Law of the United States 1988 can be summarized in a convenient manner that it tries to have a kind of a promissory augury of the principles of reasonableness. In that way, reasonableness is to be determined by balancing various factors, including Section 403 subclause 2, which talks about territoriality, nationality, and the effect doctrine in giving a principal basis of a jurisdiction to prescribe for the competition or the antitrust law. Now let us see that what Section 402 of the Restatement Third of the Foreign Relation Laws of United States 1988 incorporate. It in fact incorporates the general basis of jurisdictions to prescribe, and in that respect it says conduct that wholly or in substantial part takes place within the territory. Number two, the status of person or interest in things present within its territory. Or number three, conducts outside its territory that has or is intended to have substantial effect within the territory. The activities, the interests, the status, the relationship of the nationals outside as well as within its territory, and certain conduct outside its territory by person not its national that is directed against the security of the state or against a limited class of the other state interest. So a perusal of Section 402 is imperative to draw a kind of a perspective of what you call that how the Restatement Third of the Foreign Relation Law of the United States of 1988 seems to be an improvement in antitrust extraterritorial application. With that, we should also take into cognizance the Section 403, which provides limitation on jurisdiction to prescribe, and Section 415 of the Third Amendment or Third Restatement set forth the principles governing jurisdiction to clearly apply U.S. antitrust law. Therefore, the section 403 of the restatement third provides that a state may not exercise jurisdiction over person or activities having a connection with another state when the exercise of such jurisdiction is unreasonable, even though the basis of for jurisdiction under section 402 is present. Thus, what we see that section 403 of the Restatement Third of 1988 clearly provides that a state may not exercise jurisdiction over person or activities having a connection with another state when the exercise of such jurisdiction is unreasonable, even though the basis of jurisdiction under section 402 is present. The Restatement Third 403 subclause 2 lists 8 relevant factors to be considered when determining whether exercise of jurisdiction is reasonable. Therefore, section 415 applies the general principles of extraterritorial application of competition law under the doctrinal limit and the legislative framework of section 402 and 403 to regulate anti-competitive activities within the territorial boundaries of United States and extraterritorial boundaries of the United States. Here, your attention is drawn to subsection 1, which addresses jurisdiction over the conduct that occurs in United States regardless of nationality of the parties or the place of anti-competitive activities. And your attention is equally drawn to subsection 2, which applies that if parties intend to interfere with and cause some effect on the commerce of the United States, even though the anti-competitive conduct takes place outside the United States. Subsection 3, dear learner and viewer, is equally important, which applies to any conduct if it has substantial effect on the commerce of the United States. An exercise of jurisdiction may not be considered to be unreasonable. In the light of the perusal of the statutes and its sections and subsections, and taking a combined and a holistic perspective of section 402, 403, 415 of Restatement Third, we are in a position to have some generalization that these three sections in fact summarizes the principles of territoriality, nationality, and effect doctrine and the effect of reasonableness. However, we can say that the Restatement Third added further what you can call that a state has jurisdiction to prescribe law with respect to conduct outside its territory that has or is intended to have substantial effect within the territory. Therefore, according to Restatement Third 1988, it is sufficient to support an exercise of jurisdiction over the conduct occurring outside its territory if there are either actual or intended effects within the territory by exercising broader extraterritorial jurisdictions. Now, dear learner, we are now reaching to a juncture where we can exactly underline the ambit of extraterritoriality in the United States under the Sherman Act, the Clayton Act, and 1988, the Restatement Third Act, which has been applied extraterritorially in cases of harmful acts which were planned in US and imposed liability on non-national if the act outside the US produce consequences within American and foreign jurisdiction. The perusal of recent cases focus on the intent, element, and effect on the import and export in application of multilateral treaty And thus, what we find that the debate over the basis of extraterritorial jurisdiction, including the effect doctrine, universality principle, the passive personality principles, which has been discussed in the previous lecture, involving different nation to antitrust cases, are equally important vis-a-vis the US antitrust provisions, particularly Section 1 and 2 and Section 111 of the Sherman Act 1890 give rise to extraterritorial jurisdictions, which is further fortified by Alcoa case in 1945, the effect doctrine in US in the antitrust jurisdiction, which began in 1945 with Alcoa case, addressed extraterritorial application of competition law, and it further incorporated the notion of comity and jurisdictional inquiry as a quantum leap and between the US and the international community, which is considered to be cardinal for antitrust enforcement. Thus, the divergence and congruence of the court of law in matters of using the conflict of laws principle, particularly in the arena of extraterritorial antitrust cases, is a kind of a balancing of interest principles laid down in Timberlane case of 1983. The analysis from the legislative intent of all the enactment having direct and incidental bearing on the extraterritorial application of competition law to the subject matter jurisdiction under Hartford Fire case of 1993 and Hartford Fire Insurance Company in 1993, Morrison versus National Australian Bank Limited decision in 2010, and RJR Nabisco Incorporation versus European Community decision in 2016, and finally Escobedo versus the Securities and Exchange Commission 2019. The recent case has well focused and summarized the debate over the international conflict of laws and principles in matters of antitrust cases, and it can reasonably be asserted and to be concluded that all these laws, legislative intent, and the case law and the catena of the cases which has been decided by the US Supreme Court unequivocally and cumulatively emphasizes the distinction between legislative and subject matter jurisdiction in extraterritorial application of antitrust law in the United States. I hope that this lecture will be sufficient to understand the nitty and gritty and actual working of the extraterritorial application of the competition law or the antitrust law, in keeping in view all the theories and principles of the extraterritorial application of the competition law as to how they are applied in the jurisdictions of the United States and how the US laws on antitrust and the decisions of the court have, with the passage of time, right from 1890 down to 2024, has fortified the concept of extraterritorial application of competition law in United States. Thank you, dear learner and viewer. Have a happy learning.